Let's take a look at what the U.S. Supreme Court is considering: the constitutionality of whether murderers who commit their crimes as juveniles should be subjected to sentences of life without parole. 49 U.S. states apply life without parole across the board to juveniles and adults. There are currently more than 2,000 inmates serving this sentence for crimes they committed as minors. The U.S. states of Pennsylvania, Michigan, and Louisiana have the highest number of cases. Human rights groups have called on the U.S. to halt the practice. For more on this story, Michael Harris joins us from San Francisco. He is a senior attorney at the National Center for Youth Law and sent a report to the Supreme Court about the issue. Michael, thanks for joining us.
Oh, thank you for having me.
Explain the extent of your involvement in this case.
My organization, the National Center for Youth Law, along with many other organizations that either represent young people or engage in policy advocacy around issues related to young people, submitted an amicus, which means friend of the court brief, on the issues that were in play on this case, in this case.
Michael, the U.S. Supreme Court has previously ruled that no young person can be put to death. It's made a distinction between kids who kill and kids who don't, and many believe the courts really exerted enough control on these matters. What is wrong with life without parole for murderers under the age of 18?
Well, the reasoning that the Supreme Court used in those earlier cases that you mentioned apply here. And the reasoning involves the development of the brain of adolescents. And in essence, what science has found is that young people, teenagers, have not yet developed fully the capacity of their brain. And as a result of that, they are not as culpable for their actions as adults. This is true because in certain respects, impulse control, peer pressure, and the ability to think through consequences, young people are very different in how their brain works than fully developed adults. And so as a result of, oh, go ahead.
No, go ahead.
No, so as a result of the Supreme Court acknowledging those facts, they apply that to reach the decision that death penalty and excuse me for a second, my earpiece came out. The death penalty and then life without parole for homicide, for non-homicide cases, should be off the table. So what's at stake here now is, do those same considerations apply to such an extreme sentence for young people? Both of these cases involve someone 14 years old. Should such a long sentence be applied in those circumstances, knowing what we know about brain science?
What would you like to see the outcome be?
I would like to see the Supreme Court set a bright line test that no life without parole sentences can be imposed on anyone under the age of 18.
Now, it seems like Justice Kennedy is leaning more toward giving judges discretion in sentencing, so they may or may not be given life without parole. Would that be a good compromise?
Well, there's another aspect to this case that really makes that difficult. Many states have mandatory sentences that impose this extreme sentence irrespective of the culpability of the young person charged. And so that is not, and so the Supreme Court would have to outlaw that practice in order for there to be individualized consideration.
All right.
Generally speaking, that's how sentencing is done, taking into account the individual characteristics of the person who's being accused and convicted.
Michael Harris, senior attorney for the National Center for Youth Law, thanks for joining us.
Oh, you're welcome.